Each side will have 15 minutes to present their arguments. I'm sure our bailiff has already informed you with the cross appeal that you'll have to submit that at the time of your argument. Okay, let's go. Thank you.
May it please the court, I'm Doug Dershel on behalf of Cedar Lane Farms, and if I could, I'd like to reserve 3 minutes for rebuttal.
Thank you.
In analyzing this case, I just have to wonder, does the law matter anymore? Does the parole evidence rule still exist? Shouldn't the court enforce clear agreements? Doesn't equity still abhor a forfeiture? Do the elements of conversion still exist? Do we care about any of these things anymore? I hope we do. After the trial court decision, I'm left to wonder on these points. I trust you will restore my faith in the law with your decision here. Assignments of error 1 and 2 have to do with the lease document. It goes back to 1986. What is parcel B under the lease? Here's a blow-up of the document. It's in the records. There's a smaller version of this in your briefs. This is attached to the lease. You have parcels A, B, C, and D. D is not included. A, B, and C is included. The question here is, what is B? Mr. Besancon would have you believe that B is this little block right here. I would submit that makes no sense at all, just looking at the drawing, which is where your summary judgment test comes in. When you're looking at this drawing, there's a road here, there's parcel C here, there's parcel A over here, there's parcel D here. Isn't it pretty clear that B is all of this? I don't see how you can come to any other conclusion just looking at the item. They're trying to say, oh, it's just this little block right here. Well, what's this and what's this? That's the summary judgment test. If you say, well, maybe there's some sort of an argument that you can make that it's just that or it's ambiguous. So look at the trial testimony. What's the trial testimony? Is it just this or is it all of this? The trial testimony, Mr. Besancon himself admitted, it's not just this. These things right here, those are greenhouses. They're not in this little box. They're being used by Cedar Lane Farm. They've been used by Cedar Lane Farm since 1986 without any question. This little part right here, this is an office area for the greenhouse business. It's not in the little box with a B.
What's in the rest of the area?
Well, it depends on where you are. If you're down in this area right here, there's parking that goes with the greenhouse area. As of today, if you're in this area right here, is where the algae fields were put in, or the algae ponds, I guess you'd call them, were put in later. And if you come down here to the part closest to this access road, this is the so-called north field. I can't tell you where the line is, and there's nothing in the record that tells you where the line is. But somewhere down here, it's just farming. And so Mr. Mockimer, the president of Cedar Lane Farms, said to Mr. Besancon, I'm leasing this whole thing, but I don't have any plans on using some of this portion down here. Go ahead and keep farming it.
I have a question which may sound silly, but there's such a thing as meets and bounds. And parcels, I think, are described by meets and bounds in the official records. Am I correct?
Well, if you're doing a transfer, yes.
Okay.
To do meets and bounds.
So are there any meets and bounds in the record for these different parcels that we are now trying to?
The answer to that is a clear no.
Oh, okay.
And this
I
is all you've
regret
got.
that.
And that gets to the point, I'm jumping ahead a little bit. If the judge said, get off the north field because it wasn't included, where is that? That's where you need meets and bounds or something. You need some kind of evidence of saying, what is the north field that is supposedly not included in this lease? So if your alternatives are, well, either B is this little box, which makes no sense, or it's this whole thing, the judge came up with a third alternative. Well, it's this, it's this, it's this, it's this, but it's not something down here that's undefined. It just makes no sense. I mean, it's as wrong can be. No good deed goes unpunished. Mr. Mockimer let Mr. Besancon keep farming the part that he wasn't using, and now that's been held to be against him. Assignments of error 1 and 2 are basically that same issue. Assignment 1 looks at it on a summary judgment standard. Assignment of error number 2 simply looks at it as looking at the the evidence. Because the evidence, Mr. Besancon himself testified that the lease included more than just the little box where the P is actually located in that section. Turning to assignments of error 3 and 4, it was clearly error to order reformation of the document called the second lease extension. The court found that the so-called settlement agreement, which was nothing more than about a one-page or so transcript from the end of a deposition that had been scheduled, where the parties had worked out a deal to resolve an eviction lawsuit that Mr. Besancon had filed earlier. He's kind of a litigious guy. He filed this eviction lawsuit, the parties worked it out, and Judge Weiss found that the so-called settlement agreement, this short transcript, undated, from a court reporter, was inconsistent with the later written document signed by both parties. And Judge Weiss held that, well, the prior agreement has to take precedence. That's just wrong. A prior agreement would never take precedence over a later agreement. An oral agreement, albeit transcribed here by a court reporter, would not take precedence over a written agreement. An integrated document signed by the parties, witnessed, notarized, reviewed by Mr. Besancon's attorney. Mr. Besancon's attorney is the notary on the document. Judge Weiss said that's not good enough. That's not the real agreement. That's just wrong as a matter of law. To reform that, the judge would have to find mutual mistake. That's the law, that's the test. And no negligence in finding that mistake by the person who's complaining about it, which would be Mr. Besancon. Neither of those elements are met. First of all, I would contend there's no mistake at all. The issue, the mistake that they're complaining about, in so-called in quotes, is, was there one $3,000 payment due, or were there two $3,000 payments due? I would submit at best that's ambiguous. The second, the written document says one $3,000 payment was paid. An additional $2,400 payment was paid, explicitly labeled as consideration for the option extension. No question that that was paid. So I don't know where the mistake is in the first place. If there was a mistake, it was not mutual. Mr. Mockever, the representative of Cedar Lane Farms, didn't make any mistake. He looked at the document, said it was correct, signed it. Besancon's attorney looked at it, and gave it to them, and they signed it. And let's assume there was a mistake, assume it was mutual. The law, again, the law is what controls here. The law says there has to be no negligence on the part of the party complaining in finding that. Assuming those first two things, which is only an assumption, they were negligent in not finding that. They looked at the document, they said that in testimony they didn't read it because they trusted their attorney. They didn't bring this issue up until years later. That, just as a matter of fundamental fairness, is offensive. So if their attorney has read the document and notarized it, and now they're saying, well, they don't like that document because it was somehow had a mistake in it, I think they have a very difficult time getting over the burden of not being negligent in finding that. Assignment of error number 5 is again going back to the parole evidence rule. And what's the last word in that phrase, parole evidence rule? It's a rule. It's the law. The subsequent written document controls. The subsequent written document clearly says there's one $3,000 payment to be made. There's no dispute in the record that that was made. Assignment of error number 6. Even if you don't buy any of that, what remedy would be appropriate? So in other words, if you find somehow that there was a mistake, that the mistake was mutual, and that the Besancons were not negligent in finding that mistake, and therefore the document can be reformed to say that a second $3,000 payment should be made, which wasn't made because nobody knew that that was what was supposed to be done until the judge said that. So the judge then goes on to say, well, because you didn't make this payment that I'm just now telling you you have to make, the documents thrown out. The opportunity to be in business 5 more years from 2016 to 2021, which was the term for the extension. The judge said that's void. Again, that is just clearly wrong as a matter of law. It's not a discretion thing in the judge. It's not a finding of fact issue. It's just wrong as a matter of law. The case law is very clear. Equity abhors a forfeiture. That is a forfeiture. That is the death penalty for this business. That is saying that this business cannot be there any longer than right now. It would be gone now if we didn't have a stay of the judge's ruling, because we're into that 5-year period. They've given the notice to extend the lease, so all the other preconditions have been met, and you don't get the death penalty in that situation. If you assume all those things, which, as I said, I have a very hard time getting to those assumptions, but even if we get to those assumptions, the appropriate remedy is that they owe another $3,000. Try to make this go away. The record, again, it's in the record. Mr. Mockimer said to Mr. Besancon, I don't think that's right, but if that's the case, fine, here's another $3,000, go away. And Mr. Besancon said, no, I'd rather sue you. That was offensive. So the proper, if you get all the way down that road, the remedy is they owe another $3,000. I would submit we shouldn't get all the way down that road. But if you do, the remedy is not the death penalty. It's a judgment for $3,000. Pay, because the issue is what would put the landlord in the position that the judge is saying the landlord should have been. The case law that we cited in the brief is clear. The opposing party has cited 0 cases to the contrary. Mr. Besancon's brief is totally devoid of any case that says the appropriate remedy here is the death penalty. As to the last assignment of error, Judge Weiss found that there was a conversion of a check. I would submit, again, as a matter of law, it borders on bizarre. The check in question was paid by a company called Touchstone, which originally was a part of this case and later dismissed, payable to Cedar Lane Farms. How in the world can Cedar Lane Farms convert a check payable to Cedar Lane Farms? I don't understand that at all. The judge didn't give any reasoning for that. The testimony was that that $5,000 could have been used for the benefit of the Besancons, and the testimony was very clear that that might have been the funding that Cedar Lane Farms would use as part of a new, even longer lease with the Besancons that never got negotiated.
And you're in your rebuttal time.
Thank you.
You may proceed.
Morning, Your Honors. My name is Brian Barnard. I'm here on behalf of William and Sandy Besancon today. First of all, I'd like to begin with the issues regarding the original lease and what is Parcel B. We believe, and the trial court found, that what Parcel B is was ambiguous. When looking at the document, looking at the actual map that was included on the lease, it's not clear what B contains. What is B? So the judge correctly considered other evidence. Now, in the trial transcript as well as the brief, there's extensive testimony about what B is. Now, when looking at trying to figure out what it was, the judge listened to the testimony. First of all, in the original lease, the lessee, Cedar Lane Farms, was to pay the real estate taxes on all of the leased land. The court found through the testimony that this, and we will use the term Northfield, we believe that's a common understanding between the parties, and actually we believe that Cedar Lane Farms was the actual party to first coin the term, the Northfield. And they had never paid the taxes on the Northfield portion of this parcel. Also, the Besancons used the Northfield here continuously for over 20 years for crop production without any objection. Now, certainly Cedar Lane Farms There was some testimony that they just gratuitously just allowed the Besancons to use this. Well, the judge heard that testimony. Judge Weiss listened to that testimony. He listened to the testimony from my client, that they used it continuously, uninterrupted, as a crop field, without any objections from Cedar Lane Farms. So,
What evidence was in the record about the real estate taxes?
I believe there was a certified copy of the real estate tax map.
And what did that show?
That showed that the taxes on the Northfield portion, what we believe to be the Northfield, had been paid by the Besancons all these years. Now, at one point, there was an attempt by Cedar Lane Farms to move the taxes into their name so that it would appear that they had been paying all along. However, my client was able to stop that, the Besancons, because they didn't want to let them begin paying the taxes, because then they'd have this argument that, hey, that's part of the Northfield, or the Northfield is part of B, which had never been the understanding of the parties. Now, the most telling factor, we believe, in the record is that in about 2011, there's a project that begins out on this Northfield. My client, it's actually, we refer to it as an algae project, and my client and Cedar Lane Farms enter some discussions about this algae project coming on to the farmland. And Mr. Mockimer is the one negotiating the lease with this touchstone that's coming in to build all these things. But he doesn't just say, this is my property. I'm going to just lease it out, sublease it out to Touchstone, and I'm going to run this algae project here. He goes to my client, and he says, I would like to pay you additional rent for use of the Northfield. That's probably the most telling fact in the record. He knew he didn't lease it. That's why he went to my client. That's why they negotiated a sublease for the Northfield.
Could it be that that new use of that area meant that it's no longer available for crops? So it affects not whether or not he leased it, but it affects kind of the parameters of what they had been doing.
Well, we believe, Your Honor, that it would affect that, and that's why, since it wasn't part of the lease, and since my client is farming there, Cedar Lane Farms must go to my client and say, hey, can we use this? We need some more ground. We need this area because I want to start this algae project. Now, there's evidence in the record. My client said, yes, I will sublease this to you. And then there was another sublease and kind of down the road, and the government got involved in this big project was started out there. But he didn't have the right to use it because he went and he asked my client, and there's actually a sublease that's made, an oral sublease between my client and Cedar Lane Farms, where he begins paying for the use of the Northfield.
An oral sublease?
An oral sublease, yes, Your Honor.
Why is it a sublease?
Well, I don't know, maybe I've used the wrong term. It's actually because it would actually just be a lease to use the Northfield. The sublease would then come as Touchstone. The government contractor comes in. There's a sublease there. Now, turning to the mutual mistake, we believe, and we believe the judge found, that there's a settlement agreement. There was a prior case, an eviction case, and they were scheduled for depositions, and lawyers were present, parties were present, and they were about ready to take depositions. The depositions were stopped, and the parties entered into an agreement, a settlement agreement. And the defendant admitted it was a settlement agreement in the pleadings, I believe in their answer, paragraph 24. There was an enforceable contract made that day at the settlement agreement. The terms were placed on the record. They were transcribed by the transcriber. They included clearly, and we're talking about the option here, 5-year option, it clearly included $2 amounts in consideration of that lease extension. The first one was a $2,400 payment that day, and the second dollar amount was $3,000, and that was to be paid by June 30th, 2007. Cedar Lane Farms' own counsel uses the word consideration for the option. At the end of that, both parties are questioned by defense counsel, is this your agreement? Yes. That's a contract. It's an enforceable contract. And the option is also a contract. And if the $3,000 was not paid in accordance with that contract by June 30th of 2007, it's void. You don't get the benefit of your bargain if you don't pay the consideration for it. And it was clear in the record. $3,000 by June 30th, 2007. Record's clear, it wasn't paid. There's no issue there. But that is the contract, not the subsequent second lease extension, the memorandum of it. The parties simply agreed at the deposition, this is what we're going to do. However, we'll write something up at a later date consistent with the agreement we've made today. Now, what happens when that later memorandum is written? Everything's changed. The $3,000 consideration is no longer there. It's been called something rent payable now. Numerous other assets are added to this at the end of the lease that Cedar Lane Farms gets to take. It's a mistake. It's a drafting mistake. Now, does Cedar Lane Farms want to admit it's a mistake? No. They stand to greatly benefit from the mistake. But it's a mistake. And equity will correct that mistake to be in line with the true intentions of the parties. It's clear here from the record, the deposition, which is transcribed, written down, what the agreement of the parties was. I believe the judge got that right. He's reformed that to again reflect the true agreement. And they did not pay the $3,000 for their option. Without paying that $3,000, the option is gone. It's contractual. As to the conversion, there's evidence in the record that the only reason Cedar Lane Farms came into possession of this check for $5,000 from Touchstone was because they told Touchstone that to send the check to them, that they would get it to Mr. Besancon, because it was to pay him for some of the work that he had done in building this algae project, helping with the algae project. He uses farm equipment, move dirt around and such. And the only reason that Cedar Lane Farms is able to get this $5,000 check from Touchstone is because they say, send it to us and we'll get it to Mr. Besancon. Did they do that? No. They held it out in front of him like a carrot and said, we want more lease time. You want this $5,000? Give us more lease time. But that was not the reason why they got the check. The check was for Mr. Besancon, and they kept it. And we believe, in a cross appeal, that that is a clear violation of Mr. Besancon's rights, willful misconduct. We ask for punitive damages on deny those. We've asked the court to reverse on this, as that is clear. What he did was totally in disregard of Mr. Besancen's rights.
For whose benefit was the work that Mr. Besancon did?
It was for the benefit of this algae project, and he had helped with it. This algae project has been something that both Cedar Lane Farms and Mr. Besancon were in agreement. It was basically a green, renewable energy type of operation that was going on out there. So it was for the benefit of probably Touchdown as well as the federal government. There's a number of beneficiaries to it.
Well, not the benefit of the project, but who's the beneficiary of his labor? If that's what the check was to represent.
That would have been Touchdown, I believe.
Touchdown.
Yeah, because
And was Mr. Besancon in privity of any sort of contract with Touchdown?
he was not just by a third party. He wouldn't necessarily be a third party beneficiary.
And who would be the first part? So then was Cedar Lane Farms in some sort of privity with Touchdown?
With Touchdown, yes, there was a sublease there. Yeah. If there are no further questions, that's all I have.
Thank you, counsel.
Thank you very much.
Very briefly, I won't go into the document anymore. I think it's clear enough. We've talked enough about that. Mr. Barner mentioned payment of the real estate taxes. If they weren't paying the real estate taxes, that's a claim for dollars that should have been paid. That's not the other end. He said there was no objection to, by Cedar Lane, to Mr. Besancon farming the area in question. So what? What's wrong with being a nice person and saying this land that I'm leasing, you can keep farming, you can use it. We're in the ag business, you're in the ag business, go ahead and keep farming it. What does that matter? The algae project came along and used part of that area in that, it's shown in the drawing there. And Mr. Barnard says, well, they wouldn't need to pay any more if that was already leased. The testimony from Mr. Mocker was the only reason he offered him more money was because he was kept harassing him. Said, look, I'll give you a couple $100 a month or whatever it was if you go away. And obviously it didn't buy peace. Mr. Besancon still sued him. And Mr. Barnard tellingly referred to an oral sublease. He didn't make a mistake there. That's what the parties, that was the term that was used. You can't have a sublease if there's not a lease. I would submit an oral sublease is kind of a curious concept for real estate, but you can't have an oral sublease if there is no underlying lease. That's what it was called. That means it was leased to Cedar Lane Farm. The settlement agreement, I will read to you this. It's in the record. It says there will be a $2,400 payment paid today for consideration of a lease extension for an additional 5-year period extending from 2017 to 2021. That $2,400 was paid. That's in the record, undisputed. It says, and also, I'm quoting here, in consideration of that extension, a second payment will be made by June 30th of 2007, the amount of $3,000. That was paid a year early. The record is undisputed about that. What they're trying to argue is that the $3,000 that was paid was for something else. I would submit it was not for something else. The testimony from Mr. Lockerer was undisputed, that payment was made. That's what it was for. And again, our worst case scenario should be that if that's wrong, that he owes another $3,000. The remedy is not the death penalty for canceling the extension, the 5-year extension that is required to keep this company in business. This is a very important matter. Cedar Lane Farm is not a matter of these greenhouses you can just pick up and move somewhere.
And counsel, you're out of time.
Thank you.
Thank you. Thank you, gentlemen, counsel, for your presentations and arguments to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides and released on our website. Thank you.
Thank you.
And thank you for your attention in this matter and for listening to my remarks. I made them brief as possible. Take care. Bye-bye.